Assalamu alaikum and welcome to the free legal advice show at British Muslim TV. My name is Riffat Hussain and I am with you for the next hour. As our regular viewers know, the free legal advice show is here to help our viewers with any legal questions by providing answers and guidance in respect of those issues that may be arising. You may participate in our show in one of two ways, either by calling the studio on the landline number at the bottom of the screen and speaking to me live on air. This will help me understand your question and also allow me to ask any additional questions that may assist me in providing a more thorough answer to your query. If you prefer not to speak to me live on air, then you may wish to send your question through our WhatsApp group. Again, you find the number at the bottom of the screen, so please feel free to send your questions through. We have many of our viewers asking questions about the language in which they can send the questions. English or Urdu is fine, and I can address both of those for you. Make sure that you provide sufficient detail within your question to allow me to understand what your query is and to provide you with the fullest answer possible. There may be occasions where I have insufficient information to give you an answer live on air. In those circumstances, I will ask you to leave your number with one of our team and I will call you back after the show to provide some further relevant guidance after exploring your circumstances further. As always, any advice given as part of this show is free of charge and you will not be charged for any advice provided to you. I do already have some questions in, but before I move on to them, just to provide a reminder that I can only deal with matters relating to English law. It could cover a broad range of fields from immigration, family, employment to crime and other areas. If I'm unable to answer your question, then I can certainly look that up for you or signpost you to a more relevant organisation who can provide guidance and support with your query. I hope that helps. So if we move on to our first question for this evening. So the first question I have is a rather lengthy question, so do bear with me whilst I just digest that. So, Assalamu alaikum, my younger brother is travelling to Pakistan to get married. What documents does he need when he is there, and what is the application cost with solicitor fees? He has a decent IT job, living in a 3-bed house with just his mum. The girl has passed the English test already. Thank you for your question, brother, and wa alaikum assalam wa rahmatullah. So, firstly, congratulations to your brother on his engagement, and I hope all goes well with the forthcoming marriage. With regards to the visa application, there are a number of specified documents. By specified, I mean the immigration rules in the United Kingdom sets out the documents which are mandatory and would expect to be provided for an application to be successful. Goes without saying, a marriage certificate would be one of those documents to show that a marriage has taken place. It needs to be a valid marriage in the country that it does take place in. So if it's a marriage in Pakistan, then the marriage must be a valid marriage under Pakistani law. The other documents that would be required is there needs to be generally evidence that the couple have met. Photographs, any other evidence. Evidence that your brother has travelled to Pakistan as well would assist, so flight tickets, any other information that he can provide in relation to that. The next requirement would be, with regards to the marriage as well, he will need to show that he is free to marry. So if there have been any previous long-term relationships or a previous marriage, then he will need to provide evidence, documentary evidence that those relationships have now ended and he was free to enter this marriage when he does. The next stage is to provide evidence, the financial evidence. And this is usually where most people find the rules rather confusing. There is a requirement that evidence be shown that for an individual who is employed, they have a gross annual income of £18,600. Generally, the Home Office would want to see 6 months' worth of wage slips and corresponding bank statements to show that those funds have been deposited in the account. The Home Office may make inquiries, or the Entry Clearance Officer may make inquiries with the HMRC to ensure that the relevant PAYE records match the information that has been provided. In addition to that, you mentioned that the girl has already successfully passed her English language test. Just please do ensure that that is an English language test that is approved by the Home Office, and that it is at the correct level. So for entry clearance purposes as a spouse, that would be at level A1, which is the most basic of levels. For Pakistani applicants, a TB test is also required. And again, the approved clinic will be able to guide your brother and his wife to be in respect of that requirement. But a valid TB certificate must be submitted with the application also. In respect of accommodation, you touch upon that your brother is living with your mum. It's a 3-bedroom property. He's only required to show that there is a bedroom that's for the for the exclusive use for him and his wife. And if the property is not owned by your brother, then he will need to provide a letter from your mother or the owner of the property confirming that they are happy for him and his wife to reside in that property, and evidence of their ownership and or occupancy, but also evidence of your brother's occupancy as well would be helpful. So those are the requirements. In respect of the fees, so there are 2 components to the application fee. There's the actual application fee, and then there is the immigration surcharge. Both of those are paid at the time of making the application, and are usually paid online in the local currency, so in this case in Pakistani rupees. How much will solicitors charge you? It depends on the solicitor that you instruct. It can vary between £800 to £1,000+. Depends on which solicitor is providing the service. There may be additional charges if you are wanting, for example, a same-day service or a speedier service. But make those inquiries with any solicitors. Usually most solicitors will provide you a fixed fee quotation based on your circumstances. So the price can vary from client to client. If you have all of your documents prepared already and it's not going to take as many hours to prepare the application, you may get a lower quote. If, for example, somebody is needing some extra guidance with sourcing documents, and that more work needs to be put into collating and sorting out those documents, then they may be provided with a slightly higher quote. But most solicitors will now offer you a fixed fee quotation. Just ensure that they're telling you what that entails and giving you a thorough breakdown of exactly what that work entails before you make that decision. Again, there may be, depending on the solicitor you instruct, VAT applicable on those prices as well. I hope that does answer your question, and again, best of luck to you and your family. Moving on to the next question. Assalamu alaikum. Alaikum assalam wa rahmatullah. I wanted to know, I have my cousin who is of French nationality. She doesn't need a visa for the holidays. She wishes to come to London for December 21 to December 29 of this year. Her French passport expires on 31st of January 2022. Will she have the authorization to enter the territory without any problem? Thank you a lot. It depends. Most countries will require at least 6 months validity on a passport. So if the passport is due to expire at the end of January 2020, then the likelihood is that no, they will not be permitted into the United Kingdom. And therefore the better solution would be to renew the passport, if possible, before entering the United Kingdom. Make inquiries with the authorities, make inquiries particularly with the airline that you wish to travel with. But as I say, usually the guidance is that there is at least 6 months worth of validity on your passport if you are entering a territory So I envisage that your cousin may unfortunately experience problems or may even be refused the entry. Before I move on to any more WhatsApp messages, I believe we do have a caller on the line, so I will take that call. Hello, assalamu alaikum.
जी, वालेकुम सलाम.
जी मेरे भाई.
Hello.
Yes, hello.
जी, hello.
जी, hello, assalamu alaikum. Can you hear me?
Can you speak Urdu?
जी मेरे भाई, जी.
तो मेरा मसला ये है कि किसी ने एक पार्टी ने मेरा घर रिपोजेस किया है, फेक डॉक्यूमेंट्स इस्तेमाल किए हैं डॉक्यूमेंट्स, और इसका क्या हाल है?
मेरे भाई यहाँ यूके में किसी ने आपकी प्रॉपर्टी पोजेस की है?
जी जी, उस पे कब्जा किया है और झूठे पेपर बना के डॉक्यूमेंट्स जो हैं वो बिल्कुल सब फराड है, धोखा है. तो इसके लिए आप कोई वकील दे सकते हैं?
मेरे भाई आपने कोई लोकल प्रॉपर्टी लॉयर देखना होगा, लेकिन आपने पुलिस में ये रिपोर्ट की है अगर आपके साथ ऐसा कोई फ्रॉड हुआ है?
ऐसा करते हैं कि मुझे मैं उस पे व्हाट्सएप पे मेरे साथ ये नंबर मेरे पास है, व्हाट्सएप पे मैं आपको ये तफसील बताता हूँ. इस पे आवाज बहुत कम स्लो आ रही है, मुझे कान में सही नहीं सुना दे रही है आपकी. ठीक
जी
है
मेरे भाई, आप इंशाल्लाह अपना क्वेश्चन भेज दें तो मैं उसका जवाब आपको दे दूंगी.
ठीक है जी, अल्लाह हाफिज. थैंक यू.
Allah Hafiz, okay, just for the purposes of our viewers, so the brother asks a question in relation to a fraud matter. He has a property or had a property which he says has been possessed by somebody else who has used fraudulent documents to do so, and is seeking guidance in respect of that. Unfortunately, he had a bad connection and was unable to provide a full question or to hear a response. So he will forward the question through our WhatsApp group, and I will return to that hopefully later in the show today. If you do have any questions of your own, then please send them through, or even better, just pick up the phone and speak to me live in the studio. As I said, if language is a barrier and you prefer to speak in Urdu, then please feel free to do so. We will take a short break now, and I will see you on the other side. Come back and watch me again. Thank you. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Before we went into the break, I was taking questions from our viewers in relation to their legal matters and providing them with guidance and answers. If you have a question, then please do send that through either by calling our studio number and speaking to me live on air, or alternatively by sending that through to our WhatsApp group. Both numbers are at the bottom of your screen. I believe we have another caller on the line, so I will take that call now. Hello, assalamu alaikum.
Wa alaikum assalam, sister. I got a question, please. I got my decision 2 weeks ago, and the judge has given 2 weeks time to the Home Office. So my question is, Judge, does the Home Office can appeal after 2 weeks, or they don't have the right to appeal after 2 weeks?
So,
against the decision.
Is this an immigration decision that you received?
Yeah.
And is that in the first tier tribunal?
Yes.
Okay. And is it an asylum decision?
Yes, please.
And that was made in your favour, so the appeal was allowed?
Yeah, the appeal was allowed and that was made in my favour.
And it was 2 weeks ago?
Yeah.
That's fine. So in respect of any immigration decision made by the first tier tribunal, the party who doesn't win the appeal, so the losing party essentially has a right to challenge that decision. The challenge can only be brought in respect of a legal error in law. So it's not a disagreement with the facts or just a disagreement with the decision. The party will need to show that the judge made an error either by applying the wrong law, by applying the wrong facts, or misunderstanding your case in some way which has given rise to a legal argument. You're right in identifying that the deadline for that is 14 days. And so if the Secretary of State, the Home Office in this case, wishes to challenge the decision, on the grounds that there is a legal error, then they must do so within the 14 days. There are occasions sometimes where parties may apply for an extension of time and have the court give them more time to prepare the challenge, but generally the time limit is 14 days. You say it's been 2 weeks, so that's your 14 days gone, brother. Have you heard anything further from either the court or anybody else in this matter?
No, I didn't hit anything from them yet, but the 14 days will be finishing on Wednesday.
And are you legally represented?
Yeah, I have the legal representative, yeah.
Okay, and was yours an online appeal?
That was online appeal. My court was on video call, hearing was on video call, everything, yeah.
Yeah. So if you're legally represented, there is an online appeal process, brother, where the documents in your appeal are sent between parties digitally, so they're not sent in paper version as they used to be. The advantage of that system is that your legal representative will be able to log into the HMCTS portal, and they will be able to see whether or not the Secretary of State has exercised her right to challenge this decision. So it's
after 14 days, yeah?
Yeah, I mean, it's advisable to wait the 14 days because they have up until that point to challenge, and it may be that they put in a late challenge. But it's advisable to keep in contact with your legal representative. They will check online to see if the Secretary of State has exercised her right to challenge, and they'll be able to guide you from there. But yes, if the Home Office does identify a legal challenge, then they may challenge.
Okay, thank you very much.
You're welcome. Thank you very much for your call. Thank you. So, brothers and sisters, if you have a question that you wish to discuss with me, please pick up the phone and speak to me live in the studio, or do send through another message on our WhatsApp group, and I will pick that up for you. I do have a number of questions waiting, and thank you so much for your patience, because I know that some of you eagerly await the answer to your questions, and I do endeavour to try and get through them as quickly as possible. Right, so we have a question here, unfortunately from a sister who is making an inquiry on behalf of her sister. I want to ask about my sister's husband, who is an abuser, hitting her. There are no children. She's only been in the UK for 2 months, but she is not willing to come out. Excuse me. He did the same to her in Pakistan. From his side, this relationship has ended, but she is not willing to come out. And I am so sorry to hear about your sister's predicament, and it's one that we see, unfortunately, on a very regular basis in practice. Your sister, I'm assuming, is in the United Kingdom on a spouse visa. She will probably have anxieties around her status and what will happen if she does leave her husband. There may also be the societal stigma around her leaving her husband, even though he is abusive. The only advice I can give is that legally there are options available to your sister, but she does need to take those steps to access the services that are available, to take those very difficult steps to reach out for the help that's available before anything can change for her, really. She may wish to discuss this with her GP. That may be a safe and secure place for her. She may have other avenues of discussing this information with professionals. And if she finds that she's in imminent danger, then she can contact the police by calling the emergency 999. Or if it's not an emergency, but she still wants the help of the police, with the assurance that she will actually be listened to and protected, then she can contact the non-emergency 101 number. I can't tell your sister what to do, although, you know, that it's tempting. it is a step that she needs to take, unfortunately. But there are many, many services, and there are secure immigration routes as well. But she will need to take that step to get the advice, to get the support, to make herself safe and secure before that advice can be delivered to her and assistance provided to her in securing her immigration status in the United Kingdom. But I do wish her all the best with that. I have another question. So the question here is, Assalamu alaikum, sister, I want to marry. I am already married. So other one want to bring from Pakistan, give me some advice. So walaikum assalam. So in respect of polygamous marriages, they're not permitted under English law. If you are already married, then the entry clearance officer will need to see evidence that your first marriage unfortunately has ended before you will be permitted to invite a second wife from Pakistan to the United Kingdom. So unfortunately, that's the short answer to your question. It's probably not a helpful one, or certainly not the one that you were wanting, but that is the legal position in respect of your query. We have another question from our brother. I have been receiving minimum wage for 80 hours only. I'm not entirely sure I understand this question, but our brother asks, I have been receiving minimum wage for 80 hours only, and other 90 plus hours I work in the month, I only get £6 per hour. So a question maybe around the national living wage, that there is a legal obligation for employers to pay the national living wage. And therefore, if your employer is in breach of those laws, you may seek to challenge that. And the best way to do that initially is to speak to your employer and advise them that you are being underpaid, that they are under a legal obligation to pay you properly and in accordance with the law. If they refuse to resolve this, then you may wish to seek to ask for their grievance policy. Again, all employers are required to have a grievance policy that you can access and pursue with them. Again, follow the steps within that grievance policy. It may involve you putting your complaint in writing, although it probably would be better to do that from the outset, so there is a clear record of what has or has not been discussed between you and your employer, rather than there later being a situation of he said, he said. If you find that you are having verbal conversations with the employer, then you would be well advised to make contemporaneous notes. So write down immediately when you spoke to them, what time, where it was, and what happened as part of that conversation. And if anything was agreed, what was agreed. If you find that the situation is not resolved and your employer is still not paying you properly, then you may wish to escalate that into a formal complaint and even legal action. Again, best guidance provided in respect of this would be on the ACAS website. They have a lot of self-help guides in respect of employment law, and also have a helpline where you can contact them and they will provide some further guidance to you. You may find that eventually you are needing to go to an employment tribunal. But the other situation that arises in these situations, however, is that the employer suddenly panics and you find yourself out of employment. Again, if you can demonstrate that your employer has dismissed you because you have asserted your right to the national minimum wage, then that would constitute unfair dismissal. And so it's important that you do keep accurate records, so that if such an eventuality arises, that you do have that evidence to support any future employment tribunal claim. But I hope you do get that resolved without having to go any further within the legal routes. Thank you for your question and taking the time to send that through. We do have many more questions coming through. We have a question from one of our viewers who says, "Dear Riffat, could you tell us about making a will? What is the best way to make a will about property and other matters?" And that's a question from Mrs. Ahmed. Mrs. Ahmed, continue to listen to and watch our show. I will answer your question on the other side of this break. Thank you. Assalamu alaikum and welcome back to the Free Legal Advice Show. My name is Riffat Hussain and I am your host this evening. Just before we went to break, I took a question from Mrs. Ahmed with regards to wills. Mrs. Ahmed asked whether how to make a will in respect of property matters. Now, wills are a way of communicating your wishes on the distribution of any wealth and your assets in the event of your death. If in the absence of a will, the law then decides what happens to those assets and wealth, and it may not necessarily reflect your wishes as to what you wanted to happen and how those assets are distributed. With regards to making wills, there are a number of ways you can do this. You can draft your will yourself, or you may instruct a lawyer or another suitably qualified individual to draft the will on your behalf. Just be aware, however, that in order for the will to be legally valid, it does need to be witnessed by a lawyer or again, somebody suitably qualified. So you may write your will and it may express your wishes, but it will not be legally valid unless it has been witnessed. Formally witnessed and signed to say it has. So that's the only issue that you need to be aware of. But other than that, if you feel confident in writing your own will, then go ahead and do so. If it's not as straightforward and there are further complexities, or you would be more confident in having somebody draft that on your behalf, then do instruct one of your local solicitors to draft that for you as well, and then have that witnessed and signed to say it has been, to make it legally valid. I hope that answers your question, Mrs. Ahmed, and thank you for taking the time to send that through this evening. We have another question here in respect, well, we have a number of questions here. So I will go through those as I can. Again, if you have your question waiting, then please do send that through, and I will pick that up. So we have a question here from one of our brothers who says, "Assalamu alaikum, alaikum assalam wa rahmatullah. I made an application, an immigration application, and it's been 8 months without a decision. And the brother is worried that there may be a problem with the application." That there is no problem with the application, or the likelihood is that there is no problem with the application. If there was, generally the Home Office would contact you, particularly if there's further information needed as part of that application. The delay probably is just the general delay being experienced by most people making applications to the Home Office at the moment, who are experiencing significant delays. So I would say allow a little bit longer. If you haven't heard in the next couple of weeks, then maybe contact your local MP or write directly to the Home Office for an update. If you do find that it becomes excessive and you're still waiting maybe a couple of months down the line, then speak to a legal representative to see if there's anything that they can do. You may want to just make a formal complaint to the Home Office directly as well. That I generally find generates some kind of response from the Home Office in speeding up an application also. So I hope that answers your question. Moving on to another question, we have Assalamu alaikum. I have a question. I was born in the UK back in 1978, and therefore I was granted British citizenship. I live in the UK with 3 of my children who were born outside of the UK. However, they have the British citizenship. Could they pass the citizenship onto their children? And this is a question from Siraj. So thank you so much for that question, Siraj. With regards to passing on citizenship to children, then that would depend on whether your children have citizenship by descent or otherwise than descent, and it would be worth checking their paperwork. I can't, off the top of my head, remember which one they would be granted, as you would have been granted citizenship without descent, but your children were then born outside the UK. So it's worth checking that. If they are without descent, then they can pass it on. If not, then the children will not be able to pass their nationality on. I will double check that for you and give you a more fuller answer either later in this show, time permitting. If not, then next week in my next show. We have another question. This question comes from, I have been watching your program. What about a husband who abused and hit and is not willing to make the marriage happy? It's happened to my sister, but my husband is so good. Well, alhamdulillah, at least your husband is good. With regards to your sister, and we had a similar question earlier in the show, there are options for anybody who finds themselves in an abusive relationship, British or otherwise. There are options, and there are establishments out there who are able to offer assistance in such circumstances with individuals who are here either on a spouse visa or with limited leave to remain, so don't have permanent residence in the UK. There are a number of barriers that they face. The first barrier being that they don't speak the language generally and don't understand the system. The second barrier being that most of these visas are granted with the condition of no recourse to public funds. That basically means that the individual is not entitled to any public funds, so they're not entitled to benefits, they're not entitled to a place in a refuge, because that would be funded through public funds. And so we find that a lot of individuals in that situation simply have nowhere to go and are very hesitant to then leave that situation, even though it is a difficult situation and it's an abusive relationship. At least they are secure in knowing where they are and they have a roof over their head. I have touched upon this in previous programs. Any individual facing domestic abuse who does not have permanent residence in the UK and has a no recourse to public funds condition can apply for a domestic abuse concession for access to public funds, which will allow them to access support of a domestic abuse charity, a refuge, secure accommodation, and also public funds whilst they resolve their other immigration issues. So there is help available. There are many organizations willing to help and listen, but you do need to take that step. You do need to speak to somebody to alert them of your situation, to get yourself to a safe place, and then speak to a solicitor to see if your immigration status can be resolved also. But thank you again for that question, and I'm so sorry to hear that your sister finds herself in that situation. Right, so we do have a number of questions here still to get through. I have got them slightly muddled up, so bear with me whilst I find another one that I've not yet gone through. Forgive me, some of these are rather lengthy and somewhat muddled up, so I will go through them as quickly as I can find them. Right, we have a question here from a brother or sister who is applying for a visa to come to the UK on a temporary basis. The question is, and again, slightly jumbled up, but it's in relation to an immigration application form. It starts off by saying, tick to certify maintenance for migrant. Does it mean that he needs to show the maintenance funds? He's a doctor from Pakistan coming to the UK, Tier 5 Global Exchange Program, temporary work, government authorised exchange program, question marks. So there's some information within the question as to what it is that this individual is looking for. So we have somebody wanting to come to the UK on the government authorised exchange visa. Now, the government authorised, so this is for temporary work. So this isn't a visa for long-term employment or to remain in the United Kingdom, but it is a government authorised exchange program. Now, the questioner mentions the Tier 5. Now, it may be just that the old terminology has been used, but the Tier 5 has been replaced by this new government authorised exchange visa, so that there is a distinction. I believe the question is, do they need to show maintenance? Then the question is, yes, they do, unless they are exempt. And the Home Office guidance provides situation when an individual may be exempt, and usually that would be if they've got a sponsor there to provide the maintenance part. But there are a number of components to this. Now, in order to apply for this visa, you have to demonstrate that you are coming to the United Kingdom for short-term work, work experience even, or training. And you are, or for an overseas language program. And it has to be a government authorised scheme, so it can't be just any kind of work experience, but one that's already been approved by the government. You need to have a sponsor. A UK government approved sponsor will be required in order to gain entry, and then there are some eligibility requirements as well. So the eligibility is a certificate of sponsorship, but then the next one is the ability to maintain yourself. And there are figures given within the guidance if you are required to pay the maintenance. So again, have a look at those, but you must have at least £1,270 in your bank to show that you can support yourself, and it needs to have been there for 28 days. We are going to move on to a short break. Please continue to watch the program, and I will continue with the question as soon as we get back from this short break. Thank you. Assalamu alaikum and welcome back to the final segment of the free legal advice show on British Muslim TV. I continue to be your host, and my name is Riffat Hussain. Just before we went to the break, I was answering a question from a brother in Pakistan who is seeking to come to the United Kingdom on a government-approved exchange program for work experience. The question, I understand, was in relation to whether maintenance needs to be shown, so whether a sum of money needs to be shown in order for the application to be successful. And I confirmed that there is a requirement, or at least one of the eligibility requirements is that the maintenance is demonstrated, money in the bank account for at least 28 days prior to making the application, and the sum of £1,270. And there are some further eligibility criteria there. If you are going to be supported by your employer, then the certificate of sponsorship must confirm that, and that the employer will need to complete the maintenance section on the certificate in order to satisfy the entry clearance officer that those requirements are met. There is a section for additional data. So I hope that does answer your question. But if the question was, is maintenance required, then the answer is yes. And I've specified the levels to which it is, unless you are exempt for one of the reasons specified in the Home Office guidance. And thank you for forwarding that question through. So moving on to another question. If I come back to my screen again. So we did have some questions left out from last week as well, and it looks like, I'm afraid, I'm not probably going to get to those either. And then we still have questions from this week, so I will try and get through as many of these as quickly as I am able to do so. So just going back to the questions. Forgive me, I lost my screen. So we have a question here. So we have a question in relation to the financial requirement in an immigration spouse application. That again, we've touched upon this today as well as in previous shows. Generally, the requirement is that the applicant demonstrates that they have an income of 18,600 gross per annum for the main applicant. If there are additional applicants, if there are dependents, children, for example, that are being included on the application, then there are additional sums to be calculated on there as well. There are certain exemptions from meeting that financial requirement, and generally they involve disability benefits and certain other kind of benefits, which then mean that you would not, whilst on receipt of those benefits, would not be able to meet that threshold. And so the Home Office would then take, or the Entry Clearance Officer would then apply a test of adequate maintenance. And adequate maintenance means that you are demonstrating a level of income which is equivalent to national income support levels even in the United Kingdom. So that depends on your particular circumstances. But if it's an individual that's not in receipt of the specified benefits, then an income of 18,600 gross per annum. And there are a number of ways that you can demonstrate you are meeting that. There is specified evidence, so there are particular types of evidence that the Home Office will expect to see. So, for example, from employment, they would expect to see salary slips for at least 6 months prior to making the application, personal bank account statements that show that money has, or your salary has been deposited into the bank account. So there are different ways of meeting the requirements. I hope that answers your question. So we have another question here. Assalamu alaikum, alaikum assalam wa rahmatullah. My brother's appeal was allowed, and he has not heard anything from the Home Office for over 4 months now. Could you please let me know where I need to write regarding when the work on court order? Thanks for your time and consideration. And that's a question from our brother Rahman. So, brother Rahman, if the I'm guessing this is an immigration appeal. If I'm wrong, then please let me know. If the appeal was allowed, then and the Home Office hasn't challenged that decision, the Secretary of State has a right to challenge the decision within 14 days if she feels that there are grounds, legal grounds to do that. If it has been 4 months, then generally that would mean that you would have heard by now if the decision had been challenged. If you're unsure, then you might want to ring the tribunal service and find out. Give them your appeal number, your brother's details, and generally your brother will need to be present to provide consent for the tribunal service to speak to him. they will be able to tell you whether there is an ongoing pending appeal or whether the Secretary of State decided not to exercise her right of appeal. If it is the case that there is no appeal, then it would seem that your brother is simply waiting for his decision, in which case the decision, it may be that the Home Office is carrying out its background checks in order to issue a decision, and those can generally take between 3 to 4 months, usually more around the 3-month mark, but it's not unknown for it to be slightly longer. If you have now been waiting for 4 months, then the best way to proceed is to contact the department that was dealing with your application. You'll have their contact details, an email address, for example, on the letters that you receive from them. They will be able to then forward that to the implementation team, and the decision can then be implemented. You may want to seek the assistance of your local MP. They can write to the Home Office and express their views on the lengthy delay in issuing the decision to your brother and implementing the tribunal decision. But I hope that provides you with some guidance. But it's not uncommon, as I say, for the Home Office to take this length of time after an appeal for the appeal to be implemented, because there are some security checks and further paperwork that needs to be completed before that decision is issued and the biometric card is sent through. But follow those steps through just to make sure that there isn't a pending appeal and you're not simply waiting for a court to decide whether or not this appeal should continue to be allowed, and that it's not a faulty decision in the legal sense. So I hope, Brother Rahman, that answers your question, and that your brother does receive his status documents very shortly. We have another question, so just moving on to that. So this is again an immigration question. So we have a question in relation to, I want to ask, if my son is a cancer survivor and has OCD, is off work, can he not apply for his fiancé visa whilst he's on benefits? Now it says in brackets ESA, so I'm assuming that means employment support allowance. Employment support allowance is not one of the benefits which would exempt your son from meeting the 18,600 threshold for the immigration application purposes. It may be, however, that if your son is out of employment due to ill health and serious ill health by the sounds of it, then he may be eligible for other benefits. For instance, he may be eligible for personal independence payments if he's receiving further assistance. And so make those inquiries. Speak to your local Citizens Advice Bureau, who can help your son complete a benefits check. If he is not claiming benefits he's entitled to, firstly, obviously, he needs to access the help that's available whilst he is unemployed, to make this process easier for him, but it may also assist him with inviting his fiancée to the United Kingdom. But employment support allowance, unfortunately, is not one of the benefits that allows him to be exempt from the 18,600 earnings threshold under the immigration rules. So I hope that answers your question and helps you with moving forward in resolving your query. And thank you, as always, for taking the time to send through your question and participating in this show. So we are just going through some further questions, but just to say thank you to Mrs. Ahmed for your lovely feedback. And it was a pleasure to answer your question. I'm glad that you found that helpful. So we move on to the final minutes of this show this evening. We do still have a number of questions outstanding, and I do apologise sincerely if I've not managed to get through your question today. I will try to pick up any questions that I've missed and start with them in the show next week. If it was from last week and I have missed it and I've not managed to pick it up today as well, please feel free to send it through again. Inshallah, I will try and get through them as quickly as possible for you. So the next question that we have, just probably the final one for this show, is in respect of biometric residence cards and the delay in them being sent through. Unfortunately, there is horrific delays with respect to biometric residence permits being issued by the Home Office at the moment. I don't know the reason behind this. I'm just aware that there are quite significant delays. There are a number of ways that you can demonstrate your entitlement, either your entitlement to work, your entitlement to public funds, or your right to rent. And you can find those details on the Home Office website. Your employer and various other agencies will be aware of how to access this information. But that brings us very close to the end of this show. So I finish by saying thank you so much for participating this evening. Thank you for taking the time to send your questions through. Inshallah, I will be back again next week, Monday, starting from 7 p.m. Please do join me then. Assalamu alaikum wa rahmatullah.